Thank you, Raj. Good evening, everyone. I again thank you for joining us today and hope all of you are in good health and keeping safe. I would like to introduce my co-panelist, Dr. Sanjeev Gimawat, Executive Director and Group Company Secretary, Dalmia Bharat Group. Mr. Suharsh Sinha, partner at AZB. He's an insolvency and bankruptcy practice. Mr. K.R. Narayanan, Vishwanarayanan. He is a corporate transaction advisor, having first-hand transaction experiences in companies like India First Insurance, DSP Merrill Lynch Mutual Fund, Birla Life Mutual Fund. Mr. Suraj Malik, he's tax partner at BDO India. Mr. Rahul Dhawan, who's a corporate legal advisor and having rich experience in transaction documentation and have worked with Lakshmi Kumaran and Sridharan law firm. And also I welcome Peter Wuss, who is partner at Loeb Smith Attorney, an offshore corporate law firm. So welcome everyone. Friends, in this third session today, we are deliberating on tax, legal and regulatory aspects of M&A transaction. M&A transactions, as we all know, are complex and very time consuming, and they need very proper planning, strategizing at each stage, whether it's time of deciding the structure of a transaction, carrying on due diligence, arriving at mutually agreeable valuation, deciding on consideration and payment mechanism, and even while putting in the agreed terms in a document and executing a definitive agreement. The first thing after we have closed the parties, we discuss or deliberate upon is the structure of a transaction, which can vary from being an asset purchase and taking the liabilities only related to the asset we are taking, or it can be an acquisition of an entire company by way of share purchase. Another way which we do is mergers of 2 or 3 entities together. The consideration or the mode of payment, whether it has to be an equity or cash transaction, is also to be decided upfront. And time of consideration, whether how to make the payment, whether the payment is to be done in a one go, it has to be deferred and linked with various stages and approvals, or and the escrow, whether we need to have an escrow or duration, and the percentage of escrow. We recommend our clients to decide these things at the initial stages only of any transaction to avoid any future challenges. In any M&A transaction and structuring of an M&A, tax plays a very important role. While we advise our clients to look into and very carefully analyze the taxation aspects during their due diligence process, because tax planning plays a very important role in at every stage of the transaction, be it during the investment or exit of an investment. In case tax planning is not done properly, we have seen adverse effects of depleting of the shareholders' value and loss of a sense of the entire M&A transaction. Apart from that, the challenges which we face in M&A is the other regulatory compliances and what approvals we need. In India, we have plethoras of law which is there governing companies, starting with Companies Act, wherein there's a detailed process and procedures which we need to follow, starting from the board approval, shareholders approval, need of NCLT approval, RD approval in some transactions. For cross-border transactions, we have to comply with FEMA laws, RBI requirements, pricing guidelines, various reporting requirements. In case of listed companies, we have issues like procedures under ICDR, takeovers, and these days SEBI is very proactive in insider trading, so we have to ensure the compliances of insider laws as well. For specific nature of companies, competition law is also very important. We need to obtain pre-approvals of Competition Commission and also ensure compliances in our agreement. There are other sector-specific laws which are there, like for insurance sector or telecom sector, wherein we need to obtain approvals of these sector regulators. Environment laws and labor laws, which we used to take casually earlier, they have also become very stringent these days with increased awareness. Latest amendments in labor laws is also to be considered. So friends, while structuring or while advising any M&A transaction, these approvals, etc., also have to be kept in mind, because wherein the sometimes approval takes a lot of time, thereby losing parties can lose the essence of the transaction because of the delay approval. So we suggest our clients to link the payment, if possible, with some of these approvals also. And what all approvals are required should be considered pre-hand in case of a transaction. Regulators these days have become very stringent. They are introspecting each and every transaction with very closer eyes. We have seen what is happening in PNB housing these days, wherein SEBI has questioned the requirement of valuation report basis the articles of association of a company. So a very close look into the transaction structuring, all the pre-necessities of approvals, etc., should be decided upfront and discussed upfront between the parties. Our panelists today are having experience from various fields of law and industry, whom I'll request to share their first-hand experience in dealing and closing the transactions successfully. I would start with Mr. Suharsh Sinha, who is an IBC expert. Suharsh, IBC is our latest entrance in M&A field. IBC is introduced only in 2016, suspended for a year, and we have seen a lot of amendment also in IBC. It's evolving, and like sections like 29A or section 32A are, according to me, these are the provisions which are giving boost to M&A activities in India. But we have also seen a lot of delay happening in IBC transactions because of litigation. So what is your stand? What is your view how IBC is affecting M&A space? Over to you.
Thank you. First of all, my apologies for being late. I was caught up on another call, so my profuse apologies. So I think, IBC has probably been one of the most landmark legislations since liberalization, I would say, since 1991. And I say that because I think this is the first time in the history of corporate India that we are seeing hostile takeovers happening. Because till date, I don't think, even the other experts on the panel who may have more experience than me, very few hostile takeovers have taken place in India, because you always need the consent of the promoter and the incumbent manager for change of control to take place. So I think to that extent, IBC has really been a game changer. And there are 2 or 3 aspects of IBC which have facilitated it. The first is that it is a creditor in possession model, as opposed to a debtor in possession model, which we have in the US under Chapter 11. So India follows the UK model of administration, where the moment an insolvency petition is admitted, the incumbent managers are dispossessed, are suspended, and the directors are dispossessed, and a resolution professional appointed by the creditors is appointed. And that resolution professional runs the company as a going concern. So the primary threat for the managers and directors of the company is actually losing control immediately. It's not as if at the end of the resolution process you may lose control. So the loss of control happens instantaneously. It's just that it's not going to another commercial party, but to a court-appointed resolution professional. Second point to note is that initially when IBC was drafted, Section 29A was not there. I think many of us on the panel would be aware of that. 29A came about because there was a fear of moral hazard. The government felt that what does the IBC do? The IBC effectively crams down all creditors across classes and says that a certain resolution plan is binding on them. It includes not only the financial creditors, it also includes tax dues and regulatory dues and government dues. So the government felt that it would be unfair for a promoter who's errant, who has a poor criminal record, who has been running a company in an inefficient way and has made the company turn the company into a non-performing asset, etc., etc. There are a few disqualifying criteria. For such a promoter to get his own company back at a huge haircut on a clean slate leads to a moral hazard. So that was the genesis of why 29A came about in the first place. So now, if you look at it holistically, the design of IBC ensures that not only does the promoter lose control once the company goes into IBC, but his ability of getting back into the company is also severely restricted, because the disqualifications under Section 29A are not only broad in terms of scope, but it also applies to not only the promoter, but also the promoter's connected persons. So the universe of people who are debarred for those disqualifications is quite broad. So these, as a result of which, we have seen some blockbuster M&A deals. I mean, if you look at some of the large distressed accounts, SR Steel, Bhushan Steel, Alok Industry, DHFL. I'm currently, in fact, sitting in the DHFL office because we happen to be advising the administrator in DHFL. So these are all accounts which could not have been resolved had IBC not been there. Now, so I personally feel IBC has been a great success when it comes to resolution of large complex accounts. But Deepika, I totally agree with you. There is huge scope for improvement. And in my view, the scope for improvement comes from the NCLT. So the National Company Law Tribunal, which is the bankruptcy court, there is a huge backlog of cases over there. I feel that there are 2 or 3 reasons why these delays are happening at the NCLT. Number one, the capacity building of NCLT requires to be upgraded. The number of judges is, I think the maximum number of judges we can have is about 60 or 65, and there's about 33 vacancies. So half the benches of NCLT have not been staffed. Number two, NCLT judges have shown a tendency of interfering in the commercial wisdom of the Committee of Creditors. So design of IBC is that once a restructuring or resolution has been agreed by the lenders, then that is binding on everybody, and the judiciary should not get into commercial matters. They are guardians of process. As far as the process has been followed and you tick all the boxes vis-a-vis the process, they should not go into the commercial fairness of the decision taken by the lenders. But NCLT judges have shown a tendency of doing that, in spite of Supreme Court judges saying that they should not do it. And third, I feel, is that they grant too many adjournments on frivolous grounds. So there needs to be the ability of judges to summarily decide matters without issuing a notice, asking for reply, etc. So because of these 3, I mean, there are other issues which I won't go into because of this paucity of time. I'm conscious I've taken a lot of time. But because of these 3 issues, I think urgent reform is required at the NCLT. I've even written about it, a few editorials on this publicly. I think some NCLT judges also took grave objection to it. But the point is, some reform is certainly required at the NCLT level. As a design element, I feel IBC is robust, and it has led to resolution of accounts which were unresolvable under the earlier regime.
Thank you, Suharsh. You have summarized it well. I just quickly have another question to you with respect to the inclusion of 32A in the IBC, wherein the companies, the corporate debtors have been exempted from being prosecuted, which we were seeing that there was huge challenge with respect to the ongoing ED investigations, other SEBI, etc. investigations which were going on. How do you see that?
So again, I think the logic of 32A is very strong. 32A basically says that if the previous management had taken certain actions which were criminal in nature, because of which properties of the company have been attached by enforcement agencies or tax authorities or any other regulatory authority, and pursuant to the resolution, a new bidder comes in. There is an effective change of control, genuine change of control, and the old bidders are no longer in place. A new bidder comes in. Then why should the new bidder be penalized for the sins committed by the old management? The new bidder should get the company on a clean slate, should get the company with all its assets, and none of the taint should attach from the actions taken by the previous management. So that is the logic of Section 32A. I personally feel the logic is very strong. The issue that I am seeing in practice is that in spite of the fact that 32A is there, enforcement agencies, particularly the ED, in many cases have still taken the ground that the attachment subsists. And this matter, in particularly in Bhushan Power and Steel, this matter has gone up to Supreme Court. I'm not aware of the latest order in this matter, but it would be very helpful if the government agencies cooperate. Because at the end of the day, it's one arm of the government, right? It's the Ministry of Corporate Affairs, the MCA, which has passed, which is championing IBC, the Ministry of Finance, which is championing IBC. On the other hand, you cannot have enforcement directorate, tax authorities, and other regulatory authorities continuing to attach properties of corporate debtors, even where there is a genuine change of control. So I think the principle is very solid. Its implementation on the ground, I think, requires some sensitization amongst other government agencies.
I agree, Suhash. I think Supreme Court judgment will settle this, hopefully settle this for future cases. So moving forward, Mr. Gemawat, I would like to have your views. You have been at the upfront of so many domestic and foreign transactions. You have been involved into IBC acquisitions. Dalmia, you were in this Pinani Cement you attended. Then you acquired Murli Industries. So what is your take? How acquisition under IBC is different from the general transactions which we do for M&A?
Well, there are two parts to it. Yes, I completely agree with Swar's views. But first, thank you very much for inviting me. Sorry, in the emotions of responding to what Swar said about IBC, I just forgot the basic courtesy. But then anyway, I agree with the sentiments which Swar has expressed. When IBC came as a legislation, Indian industry was very upbeat about it. And it was undoubtedly a revolutionary piece of legislation. Simultaneously, there were a number of other things were also happening in India. There was an overhauling of the company law. There was IBC in place. And everybody was very upbeat about the whole mechanism. And undoubtedly, this serves a purpose in terms of our ranking as far as ease of doing business is concerned. And it helped a lot. But unfortunately, we have completely compromised the great piece of legislation. And why I say that we have compromised this? For the simple reason, Swartz has identified three reasons that why IBC failed in terms of competency, the vacancies of judges. He talked about their getting to the commercial wisdom of it. He talked about adjournments on frivolous grounds. And believe me, there is only one reason for this: quality. The quality of judges was a big issue. The attitude was so negative that the best piece of legislation they have completely compromised. I agree, these are the instances. Swartz has given instances. The fact is, a hearing which can take place in 1 day's time, there would be number of adjournments for that. Even today, if you notice, the courts are not, COVID cannot be an excuse in perpetuity. How can COVID be an excuse in perpetuity when other courts are functioning? But still, how many courts are right now performing to their optimum level? Forget about the best level I'm talking about. Even at the minimum level, they are not operating. So IBC as a piece of legislation was a great piece of legislation. But then if you see the history and the performance of IBC, in all, we have been successful in revival of only 13% of the cases. And in terms of the recovery of amount, we have not done tremendously well. We have reached up to around 39 or 40% of the amount of recovery. But then in the earlier regime also, we were at 39% or 40%, or perhaps 42%, I think, in the earlier regime. Now, if you see those numbers, then you will see that no, we have not done great work in the process. But perhaps somewhere we have reduced the timelines because of the certain strict timelines provided in IBC. But those, whatever timelines were provided, those timelines were completely compromised in most of the cases. In majority of the cases, timelines have been compromised to the extent that even the liquidation cases, you will be shocked that the liquidation cases gone beyond 1,000 days. I think average was around 460 days or whatever, but yes, then on around 1,000 days. So somewhere there is a fault. There's a fault in terms of the justice delivery system and or the implementation of IBC. But then it doesn't stop here. What the Indian industry is suffering. Indian industry, when an acquirer comes, well, of course, I will give a brief comment on 29A and 32A as well. But then largely, Today, we don't have acquirers in the market because most of the acquirers who were having those financial capabilities or the other capabilities, they themselves are under bankruptcy. So how many acquirers we have in the Indian industry today? Very few, very limited. Above all, then we have compromised as far as the justice delivery system is concerned in terms of delays. And so, to the extent, the value as far as asset is concerned, that would go absolutely down. Now, the example is that the Swartz did mention that creditors in control concept. This IPC piece of legislation is creditors in control. And I think there lies the basic fault. That a creditor, if suppose he takes over the company, his interest cannot be the revival of the company. His interest is to encash his money, to recover as early as possible. Famous English saying that a bird in hand is better than two in the bush. And obviously that principle would get applied. So basically, if you notice, the creditors in control concept cannot be the revival of the company. But then I am happy because these laws are evolving. Today, when I say that if the Supreme Court says that no guarantors would be liable, yes, that particular position where the guarantors are liable, and coupled with a change in the legislation, the pre-packaged, insolvency today, what we are having. Now, today, it might be for the MSME sector, but then tomorrow, if suppose that gets spread to all the sectors, then there would be a situation that there would be creditors in control and debtors in possession. And that would be the time that there would be a period whereby debtors or the guarantors, they would do something about revival of the company. And perhaps that would be the solution. Solution lies somewhere there. I differ with this particular concept of Section 29A. 29A perhaps might be relevant in those kinds of situations where there's a growing market, where there are so many takers available in the market. Now, 29A doesn't address what are the genuine lapses or the genuine failures and the not so genuine failures. I think unless you make that distinction and then you debar people from in terms of entering the market, I think this would be unfair to the industry. This would be unfair to even the economic growth of the nation. Swartz did point out, and I think you asked that question on 32A. The fact remains, one is the Indian industry suffers because of the the justice delivery system. There's a delay, there is no accountability, there's an attitudinal problem, there's no quality of judges at times. At the same time, when you implement these plans at the level of various states, mofussil areas, districts, and various other locations, the fact is, there is no combined feeling of making this a success, that the revival is the objective of all. And the revival, when I say revival is the objective of all, if a revival happens, state government would get revenue. But then are they really concerned about it? Whether the local authorities are concerned about it, whether those labor departments, once you acquire the company, they will just give you a notice and attaches your bank accounts for all those past dues of last 20 years. Now, is this the revival? Can the revival happen in this fashion? There would be one or the other cases, and at times frivolous cases, that gets filed in the Indian courts and they get entertained and the orders gets passed on that. So when we talk about 32A, I say that even 31 says that this resolution plan is should be complied by all stakeholders.
I agree with you, sir. That is what happened.
That says so. Then why are we talking about this? Are they really following this? The answer is they are not following this. I'm not
even
too sure.
After introduction of specific 32A, we had hard times convincing authorities that it will apply.
But then 31 also provides that this should be applicable. But then still, are they really complying with this? Now, this is what the Indian industry is facing the problems. But above all, are Indian courts coming to the rescue of these acquirers? Perhaps answer is no. Are they really following law? If suppose in these kinds of economic legislation, Article 142 gets invoked, I think then there's a challenge. I don't think that would be the fair thing to do. So this is one part in terms of justice delivery system and the Indian bureaucracy, where an acquirer would have to undergo various challenges and issues.
Sir,
and,
I would...
yeah, please.
Sorry, we have a limitation of time, but I would agree with what you have said, and I would summarize it like that: the provisions in the Act have been duly amended, brought in, but we need to do a lot of capacity building at the judiciary level. Moving forward, Suraj, I would like to have your perspective, your comments from the tax issues which we face in domestic and cross-border transactions, specifically with respect to the changes in GAR. Please give us your inputs on that.
All right, thank you, Deepika, and great pleasure to be among such esteemed company here. And the Suharsh and Mr. Gemawat, what they've said, right? There's great deal of emotion in what they're trying to express, because I think
coming from first-hand experiences of this.
And there's subjectivity in an objective law. I think tax is something different, where the law is objective and the purpose is, of course, revenue for the government. But in any transaction, the creativity goes for tax because it's a transaction cost. And as advisors or as clients become creative, the law will always catch up. And that's why we have things like GAR and all, which is essentially saying that, there has to be more substance to what is done. And just because, the form in which you do a particular transaction, you shouldn't be able to save taxes. It's been there in the law for a while. We still don't have any jurisprudence on GAR. That's, in a way good, that it's not been invoked left, right and center and there are safeguards. But what the government has successfully done over the years, and maybe last year budget was in particular targeting the garable things people did on transaction structures, and then the law got changed. So, we had one judgment, and I'm just going to talk about 2-3 themes where now we have code in law to say that you can't be very aggressive about your planning. One was this whole concept of claiming depreciation on goodwill. There was a Supreme Court judgment, not a greatly speaking one, but where silently, the concept of that if you even do a tax neutral process like a merger, but given how you account for mergers and you do a fair value accounting, if there's a goodwill that emerges, that is tax amortizable or deductible. And people started relying on it. And as I said, people get more creative once there is, the act is the act, but a Supreme Court judgment is law of the land. And a great deal of planning went into it. Today, when the law is changed, the collateral damages, while the law clearly says you can't get depreciation on goodwill, they've taken it now because the lawmaker is playing catch up. They've also said even if you pay in a slum sale or in a carve-out situation, an acquired goodwill is no longer depreciable. So the revenue authorities have taken it to the other extreme now, and that is what the code is. Similar thing, like we had this whole concept of slum sale, right, which was made. There were changes in law which was taxable, and people got into the territory of what is not a sale. Let's say it's an exchange where you do a the consideration is not in monetary terms. And again, we had jurisprudence coming in at High Court level as well to say that what is an exchange is not a sale, so you can't tax it. What has happened in law now is that they've clearly specified that irrespective of the mode of the consideration, if there is a sale, there is a taxable event and you need to pay on tax. So really the substance is what the law is trying to clarify, that you need to look at, and not just the form or not just the consideration in which you have particularly conducted the transactions. Even within slum sale, when people would have, in the past, we have anti-avoidance provisions that you can't transfer shares below a particular value, and there are rules, and there are anti-avoidance provision in relation to transferring land and other stuff. People used to often package this as part of slum sales and claim that the particular rules or the valuation principles didn't apply when you packaged a land or a share as part of a slum sale. And again, the change that not GAR but the law itself brings in today, that now if there are any of these components that are part of an undertaking, whether it is land and building, whether it's shares, securities, etc., there is a de minimis deeming value that you need to consider to price your slum sale. And this is impacting a lot of internal transactions. Let's say within a group, people used to take shelter of the fixed determinate consideration. That is slightly behind us now. So case laws are emerging. I don't think GAR is something that people should be overly concerned about. It is just the government telling people that, don't get over aggressive and, follow the law in spirit. And some of these changes, because of judicial precedents, I think the trend is going there to clarify it. The good part is none of these changes are retrospective anymore. So a lot of this is prospective. So all the plannings that went into a past, there are people who are rejoicing also that at least we will not be under litigation for the past planning, and that is legit to an extent. So that I see as a positive thing. Earlier we had situations where when the law changed, it went back 50 years, and you never knew what could come and hit you. So there is more certainty for sure, including certainty on some of the IBC related tax issues, right? Those things have got progressively clarified in terms of write back of liabilities and tax losses, etc.
Thanks, Suraj. I think this retrospective, not being retrospective, is a great relief for the international investors as well. There's a kind of a certainty in the environment to that aspect. Another aspect which becomes important is with respect to the so-called tax havens. Peter, I would like your inputs. Peter is joining us from Cayman Islands, and he is an expert in cross-border transactions and economic substance regime in BVI and Cayman Islands. So, Peter, how these changes in these economic substance regime is affecting the cross-border transactions? How do you see that? And if you can just also explain a little as to what is economic substance.
Sure, of course. Well, thanks very much for having me. I wish I was located in sunny Cayman Islands, but unfortunately I'm based in Hong Kong.
Oh, sorry for that.
No, not at all. You did get my hopes up a little bit. So I think it's fair to say that, in terms of offshore jurisdictions such as the BVI and the Cayman Islands, they will continue to be hugely important in terms of the Indian market. There's always talk of tax havens, how they will cease to be popular and how they will cease to be important. But actually, if you look at the numbers and statistics, specifically in terms of the Indian market, then I think you will find that they speak for themselves. So I just looked at the stats for 2019 to 2020 compared to the year prior, and I found that actually a total of $3.7 billion was invested into India through Cayman companies, which is actually up 267% from the year before. And the BVI pushed in with a total of $262.5 million in 2019 to 2020, up from $46 million in the year before. Now, I'm not saying that the BVI and the Cayman Islands are the most important offshore jurisdictions for India, because we all know that Mauritius and Singapore are probably the number one and the number two. But I think those, figures are really reassuring in terms of addressing concerns that people might have that offshore is going away anytime soon. I don't think it is. Now, you mentioned economic substance in your question. I think this is one of the reasons why investors, financial institutions, and so on and so forth have been pessimistic about, the involvement of BVI and Cayman in a market like India. For those of you that are not too familiar with the economic substance regime, it's basically something which was pushed forward by the EU and the OECD about 2 to 2.5 years ago to address base erosion and profit shifting. So in other words, the shifting of profits from jurisdictions such as India to offshore tax centers like the BVI and the Cayman Islands, purely for the purposes of avoiding tax. Because of course, those jurisdictions have either very low or little taxes, and the entities which would typically move their profits to those locations would have no substantial activities in those jurisdictions anyway. So it was a challenge. The EU and the OECD really pushed to tackle these issues. How did they do that? Well, they did that by starting to blacklist member states which didn't want to comply with their regulations. As a consequence of that, many offshore financial centers now, such as the BVI and the Caymans, have introduced economic substance legislation in order to avoid being blacklisted. And The enforcement remains untested because the regime is still new, but the penalties for not complying can run into hundreds of thousands of US dollars. So this is really important. And the rules basically say that if you have BVI or Cayman entities conducting certain types of activities, then you need to have physical substance in the BVI or the Cayman Islands. And that could mean having physical office space there, having employees with appropriate qualifications, generating expenditure there. And I think it's for those reasons that, many investors, financial institutions, etc., have been pessimistic about the survival of offshore jurisdictions. Now, if you look at the legislation, though, it is quite commercial and it is quite pragmatic. And I say that because it recognizes the reality that many offshore companies are used for holding purposes, or alternatively, they are used as investment funds, particularly in the Cayman Islands. And in those instances, the requirements under the economic substance legislation are significantly reduced. And so actually, it's relatively easy to comply with it in those cases where you're looking at holding companies, and actually investment funds completely fall outside the scope of the economic substance legislation. Now, there was some concern recently because I think it was on the 30th of June that the legislation was amended in both jurisdictions to capture partnerships. And so there was quite a bit of panic in terms of, clients who've historically used partnerships in our jurisdictions, that all of a sudden they need to comply with these really onerous requirements. But actually, for those of you familiar with offshore jurisdictions, you will be aware of the fact that partnerships are mostly used in investment fund structures. And again, the legislation is quite pragmatic because it realizes that there are genuine reasons for using these jurisdictions other than tax evasion. And so investment funds actually fall outside the scope of the economic substance requirements as a result. So I personally, challenge those people who think that offshore financial centers are going away. They are not. There are genuine reasons for using them. We are seeing a lot of increased regulation, not just in the BVI and the Caymans, but other offshore financial centers. But I think they will very much remain to be used for legitimate purposes.
Thank you, Peter. We also hope more transparent and compliant structures, see these kind of structures in future. Again, I'd say that you have emphasized on the compliance part. So I would now request Mr. Vishwanarayanan. Sir, if you can throw some light on the importance of compliances which are needed while entering into any transaction, from your experiences, how a non-compliance can result into the fallout of a transaction or delay in transaction.
Yeah, thank you, Deepika. Good evening to all. I think, Deepika, when you started the session, you mentioned two things actually. In a deal, right from the beginning till the end, regulatory and compliances are very important. Otherwise, it could be right. The second one which you said is about the sector-specific regulatory, which is more important in certain specific industry, which probably I can touch base. We can look at life insurance companies actually, which is predominantly have a different set of accounting also. Though it's covered under the Companies Act, the entire valuation at the time of the IPO or the subsequent unlisted companies also have to go through a embedded value calculation, which is the EV calculation in the The regulator IRDA looks into every liability. The liability is the entire policyholder's kitty, which is managed by the insurance company. And IRD plays a great role to ensure that both for consolidation, merger acquisition, as well as for an IPO, the calculation is exactly as required by the actuary. This is not only done by the internal actuary. There are a lot of professional firms in the country who carry these embedded value calculations to look at the liability in the balance sheet. So So that is one. In the last few years, we have seen 3 life insurance company which has got listed, which is the large names, which is ICICI, HDFC, and SBI. We have seen in the general insurance, one of the government New India Assurance got listed, and ICICI Lombard got listed. And in the health, none of the companies have got listed. Mergers and acquisition has happened more in the general insurance sector. On the life insurance sector, there has been no merger at all. But in public domain, everybody is aware of one merger and acquisition, which was between 2 large companies, which is HDFC and Max Life Holding Company. It did not go through more because it didn't get the approval of IRDA. Okay, it took more than 1.5 years, and at the end, the delay happened. For various Insurance Act 1938 has got a lot of restriction on these kind of mergers which takes place. So M&A becomes very much regulatory approved by the IRDA. That is one. Prior to this, the regulation had given a 26% automatic route for the insurance sector, which was increased to 49%. When they made it to 49%, also they were very clear, IRDA, saying that 51% has to be Indian owned and controlled. So the IOC regulation became very important, that even though 49 could be the FDI automatic route, 51 has to be Indian owned and controlled. They also relaxed that majority, you can say all the life insurance, general insurance, and the health insurance had foreign partners, and the foreign partners were all in the business of life insurance or general insurance or health insurance. So they relaxed something where private equity can enter. Private equity can enter initially up to 10%, and then they made it to 26%, which was treated as promoter. One such company took up 26%, and IRD approval came in. I handled the transaction also, where not only IRD approval, then the CCI approval, Department of Economic Affairs approval is a lot of time consuming and has to be exactly regulatory driven. That's something which you have to note. On the Indian owned and controlled, I will just stress and saying that 26 became 49, and the finance budget 21 recently, which was announced, the 49 has become 74. So when 74 is there, likelihood that the IRDA is amending the Indian owned and controlled regulation. So I think the transaction has not taken place, but there's really a lot of capital can come in through this, because insurance for the liability to be managed, huge capital is required, and that can be definitely come through a lot of foreign companies actually. So that's on the Indian owned and controlled.
Thank you, sir, for your insight. I think we need to actually push hard for you were saying something?
Yeah, the other industry which is also highly regulated in terms of regulatory is SEBI. You know SEBI,
yes,
which regulates the asset management company and the mutual fund. And there also recently there's a press report which says one of the large conglomerate which was trying to list the company could not get it because the sponsor of because every asset management company has a sponsor. And the sponsor had some kind of remarks in the file which is blocking it, but probably they are trying hard to get the approval. So the regulatory approval on SEBI on this public issue has also been held back. So there are a lot of delays which happens in these terms of mergers, acquisition, money raising, private equity deals, and yeah, you telling me something?
Yeah, I was saying that yes, these regulatory approvals do take a lot of time, especially in India, and regulators like RBI and insurance. SEBI, I would say, is little faster than others, but yes, SEBI is also a roadblock many a times. Rahul, what is your stand? How we can protect these kind of delays or protect our clients while the documentation process is on? Because sometimes the viability of the transaction loses because of so much of delay. And what kind of a due diligence steps we should ensure before even committing such kind of transactions? What do you think on these?
Thanks, Deepika, and good evening to everyone. Our esteemed panelists have already addressed a plethora of issues pertaining to legal and regulatory environment. And in the previous panels also, as listening to the valuation related aspects being discussed. So the key words that I noticed were the disclosure, the transparency, the positive attitude, the accountability fixation, and such things. And when we start talking of the transactional aspects from an investor's perspective, more particularly from a foreign investor's point of view, so apart from these regulatory environment, the contractual issues also become paramount. And all these things which are of utmost importance, like requiring transparency and disclosures in the transaction documents, from the first party's perspective, of course, it is expected of the second party to provide these very important giveaways in the transactions of investments and acquisition deals. But from the first party perspective, from what he's offering in the transaction is the reps, warranties, disclaimers, and indemnities. So it has to be balanced out from the perspective of interest and accountability of both the parties. You have rightly mentioned that apart from whatever we are discussing in order to maximize the investments and returns, it is very important to build the foundation right for a transaction by engaging in a thorough due diligence exercise and to construct the deal on the premise that is suitable and fruitful to all. So obviously when an investor examines the potential deal for investment opportunities, the first thing, of course, that is required to be examined is the decision over which group entity should be the flag bearer in terms of the tax jurisdictions. And as Peter has pointed out, Singapore and Mauritius remain the front runner in terms of the tax jurisdiction, the investment havens that they are. And British Virgin Islands and Cayman Islands are also not far behind. So after examining the issues that the investor can address at home first, that is deciding over the type of entity, the jurisdiction from where the investment can flow into the targeted investee company, the other points that are to be decided depend upon the discussion and negotiation with the other party, which we try to articulate in the joint venture agreement, which serves as the constitution of the understanding between the parties for a great length to come. Because the basic governance, of course, is provided by the prevailing legal structure, but the inter se understanding between the party, that is also equally important to be addressed in the right spirit, so that it gets captured in the transaction documents transparently and fairly vis-a-vis both the parties, so that it serves the purpose for which they come together to incorporate a joint venture company. So after having shaped the initial investment structure, the parties look forward to discuss and finalize over the other crucial points in the JV agreements. And if it depends upon the results that the due diligence exercise also throws up as to what kind of risks are being identified, whether they are pre-identified, potential, or foreseeable risk in future. So that paves the way for determination of the overall valuation and pricing for the stakes to be involved. So obviously, either they can cover those risks by incorporating suitable reps, warranties, and indemnities in the agreement, or it affects the acquisition price in case of the investor coming in. If the project is already set up and it contains risks that cannot be overlooked, even while additional investments being brought in, they can't be repaired to the fullest extent. So in those cases, either the promoters provide the indemnities and complete disclosures about the types of anomalies that have already taken place and how they intend to cover it up, or they offer to compensate the transaction value for the investment deal in terms of what the premium for investment should be. And
thank you. Sorry, Rahul, I'm interrupting, but we are running out of time. And I totally agree with you that reps and warranties and indemnity clauses are to be carefully drafted. I just like to add that even the material adverse effect clause has to be taken into consideration, and we should consider that what kind of approvals and delay in approvals can cause adverse effect on the company or the transaction, and incorporate it accordingly. We are running short of time, but I'll take a liberty to touch upon the last point of concern. And sir, Sanjeev sir, I would like your inputs on that. We are seeing a lot of investor awareness these days, and these proxy firms and corporate governance is like becoming hyperactive these days in all kind of transactions which are happening. So what is your take on this, whether so much of concern over minority interest is going in the right direction, or it is just something which minority investors are using to benefit themselves, and the governance clauses which are also being related to minority interest, whether they are in favor of these transactions or detrimental to them. Just quick input of yours, sir.
Sure. I think a very, very interesting question which you have raised right now. And very briefly, let me tell you that from a proxy firm standpoint, if somebody is analyzing the data and demonstrating this, that certain things are being done nicely, certain things are not being done nicely, or in a fair manner, if somebody is assessing any company's performance, its governance structure, its practices, etc., nobody would have any objection to that. And of course, as the market is growing, you will find number of proxy firms of this nature who would be giving that assessment. But the difficulty is not that. That assessment can be fair at times, that may be motivated one. So that is one part of it. The interesting element in this is the so-called minority shareholder, which you just mentioned about. These so-called minority shareholders with their own motivated interest, vested interest, they would be filing one or the other applications in the courts, and those get entertained. They don't have the legal right to file that, but then still those gets entertained. And to the extent, and I have observed this, for example, it's an established law today, and that Mafatlal Industries case, that the courts would not be getting into the valuation aspects. There would be certain decisions on these issues that yes, at times court has, even otherwise, despite of that established law, the courts have passed orders with regard to valuation, with regard to any merger scheme. That also there are stray examples of this nature. But then you will be amazed and shocked that those people who are not even having the right to file petitions, they are not even shareholders, but they're under one pretext or the other, they file some application. Legally they don't have any right, they are not 10% shareholder, etc. But then they would file. Schemes have been set aside by the courts. That no, because of their interest is getting impacted. Now what they present, how they appreciate, and that's the reason why we said that the quality of judges is very important, the attitude is very important. Why are they getting into this? Is not a mechanism of equity, it's a mechanism of a contractual arrangements at times. So I think there we face a lot of problem. Indian industry is facing a lot of problem that these things get entertained and adverse and negative orders get passed.
Thank you so much, sir. I would say that it has been an interactive, good interaction and very insightful one. We have learned about IBC, about taxations issues in the transaction, result of delays and approvals, and also the importance of documentation and various clauses in documentation. We have briefly touched upon these topics, and I think we will all agree that at this level, at a judiciary level, a lot of capacity building is needed, though there is little we can do about it. But thank you so much, everyone. Thank you for audiences for having a patient hearing. Thank you so much.
Thank you very much, Deepika. And just last one comment, and you said that we can do very little about it. No, what we are doing today, it's only we are helping public opinion to get a certain shape. And so we are doing a nice work, and I think let's keep on doing this. Thank you very much for inviting me. It was, it's indeed an interactive session. Thank you very much.
Thank you, Deepika. Thank you for the
Thank you.